The email arrived just after lunch on a Tuesday, and I almost choked on my coffee. After careful review, we're offering $30,000 to settle this matter. $30,000. I read it 3 times, feeling heat crawl up my neck. My client, Amanda Briggs, had her knee shattered in a rear-end collision. The surgery alone cost $28,000. Physical therapy added another $8,000. Her medical bills totaled more than their insulting offer. The driver who destroyed her life carried a $100,000 policy, and I was asking for fair compensation. Instead, this adjuster named Patricia Walsh sent me pocket change wrapped in corporate language. I grabbed my phone and dialed her number immediately. She answered on the 3rd ring, voice dripping with false sweetness. "I assume you received our generous offer?" Generous. That word made my jaw clench. "This isn't even close to fair," I said calmly. Patricia laughed. Actually laughed, like I'd told a joke. "Then I guess I'll see you in court," I said, and hung up mid-sentence before she could respond. That afternoon, I drove to Amanda's physical therapy session at Riverside Rehabilitation Center. She was on the parallel bars, struggling to take 3 steps with a metal brace locked around her knee. Sweat beaded on her forehead. Pain twisted her face with each movement. When she saw me, she tried to smile, but tears filled her eyes instead. "I'm sorry I'm so much trouble," she whispered, lowering herself into a wheelchair. My throat tightened. This woman apologized for being hurt by someone else's carelessness. "You're not trouble, Amanda. You're my client, and you deserve justice." I squeezed her hand gently. "They're going to pay for every single step you take. I promise you that." She nodded, but doubt shadowed her expression. She'd been fighting this battle for 8 months already. That evening, as I drove home, my phone buzzed. An email from Peterson & Associates, the defense firm. Subject line, discovery request. I opened it at a red light. They wanted to depose 6 doctors. Every physician Amanda had seen in the past decade. My hands tightened on the steering wheel. The first deposition took place in a sterile conference room with gray walls and fluorescent lights that hummed too loudly. The defense lawyer, Preston Harding, wore an expensive suit and a smirk that made my skin crawl. He started with relevant questions about Amanda's knee injury, then pivoted sharply. "Mrs. Briggs, how many relationships have you had in the past 5 years?" Amanda's eyes widened. "Objection," I said firmly. "Relevance." Preston leaned back in his chair, grinning. "Just establishing character, counselor." He continued this pattern for 2 hours, asking about her divorce, her finances, her childhood. Irrelevant, invasive questions designed to humiliate. Amanda's voice cracked twice. By the end, tears streaked her cheeks silently. Preston packed his briefcase slowly, deliberately, making sure we watched him savor our discomfort. "See you at the next deposition," he said cheerfully. After he left, Amanda sobbed in the parking lot. I sat beside her in silence, rage building like a storm behind my ribs. If they wanted war, they'd get one. For 3 weeks, I barely slept. My dining room table disappeared under stacks of medical records, bills, and timeline documents. I organized everything chronologically. The accident report, ambulance records, surgical notes, therapy logs, every receipt, every prescription, every canceled shift at Amanda's job. My assistant, Carlos, warned me over coffee one morning. "They're going to settle before trial. They always do." He meant well, but he didn't understand. I smiled faintly, sipping my coffee. "That's the problem, Carlos. They think I will too." I highlighted another document, proof that Amanda's injury was permanent, that she'd never walk without pain again. The defense wanted to drag this out, hoping I'd get tired or Amanda would get desperate. But every delay just gave me more time to build an unbreakable case. On Friday afternoon, my phone rang. "Patricia Walsh," I answered. "Final offer," she said, her voice tight. $35,000, take it or leave it." I didn't respond. I just ended the call and returned to my files, smiling. Monday morning, I drafted a formal letter to Titan Insurance Company. The subject line read, "Notice of potential bad faith liability." I detailed Patricia's refusal to negotiate reasonably despite clear evidence of severe injury. I explained how offering $30,000 when medical bills exceeded that amount demonstrated reckless disregard for their insured's protection. If a jury awarded more than the policy limit, the company, not their insured driver, would be liable for every penny. It was a warning shot across their bow. I sent it certified mail and emailed a copy to Patricia. She called within an hour. "This is ridiculous," she snapped. "I'm saving the company money." "You're exposing them to unlimited liability," I replied calmly. "But that's your choice." She hung up. That evening, I met my mentor, Harold Chen. Wait, no names from the list. That evening, I met my mentor Thomas Rivera at his favorite diner. He read my letter slowly, then looked up with something like pride in his eyes. "You just gave them the rope to hang themselves," he murmured. I couldn't stop there. That night, I researched Patricia Walsh online. Public records, court filings, consumer complaints. What I found made my pulse quicken. In the past 4 years, Patricia had been named in 12 complaints for underpaying legitimate claims. Most victims gave up or accepted lowball settlements. But one case caught my attention, a neck injury victim who'd sued for bad faith. Titan Insurance settled quietly, sealing the records. I dug deeper, finding the original complaint before it was sealed. The pattern was identical. Serious injury, low initial offer, refusal to negotiate, then panic when the victim refused to back down. Patricia wasn't just doing her job. She was following a system designed to cheat vulnerable people. I printed every page and added them to my file. The next morning, I whispered to myself while organizing the documents, "Pattern of behavior, perfect." This wasn't just about Amanda anymore. It was about stopping someone who'd turned cruelty into a career. And I had the proof. Dr. Benjamin Torres specialized in orthopedic reconstruction. His credentials covered 2 pages, and his testimony had won cases across 3 states. When I met him at his office, he reviewed Amanda's x-rays in silence, then shook his head slowly. "Whoever hit her destroyed that knee. She'll have arthritis by 40, need a replacement by 50. He agreed to testify. "I've seen this trick before," he said, signing the contract. "Insurance companies lowball, hoping victims are too tired to fight. They'll regret it this time." I felt hope for the first time in weeks. With Dr. Torres, we had undeniable expert testimony. 2 days later, that hope wavered. The defense filed a motion to exclude Dr. Torres from testifying, claiming his methods were unconventional and his fees excessive. Neither was true, but it didn't matter. They wanted to eliminate our strongest weapon. I spent the entire weekend drafting my opposition, citing case law and Dr. Torres's impeccable record. On Monday, I filed it. Then I waited. The hearing took place in Judge Catherine Brennan's courtroom. Preston argued that Dr. Torres was a hired gun who'd say anything for money. I countered with his publication record, his hospital position, and testimony from 15 other cases where his opinions proved accurate. Judge Brennan listened to both sides, then removed her glasses. "Motion denied," she said simply. "Dr. Torres may testify." Preston's face flushed red. Patricia Walsh, sitting in the gallery, lost her smirk entirely. As we left the courtroom, Preston leaned close, his voice low and threatening. "Congratulations, now we'll bury you in paperwork instead." He wasn't bluffing. That afternoon, 3 more deposition notices arrived. They wanted to depose Amanda's physical therapist, her primary care doctor, even her employer. Each deposition would cost time and money. But as I read through the notices, I realized something. They were panicking. People who are confident don't throw everything at the wall hoping something sticks. I smiled and accepted every single request. Over the next month, I attended 7 depositions. The defense brought in every medical professional who'd ever treated Amanda, searching desperately for something to discredit her. But every single doctor said the same thing. This injury is permanent. She'll never recover full function. The damage is consistent with a high-speed rear-end collision. I recorded everything meticulously, taking notes, asking follow-up questions that strengthened our case. Preston grew increasingly frustrated. During the final deposition with Amanda's orthopedic surgeon, he snapped his pen in half and asked to take a break. I sat there calmly, realizing what had happened. They'd built my case for me. Every deposition transcript became evidence. Every doctor's statement reinforced Amanda's suffering. Preston thought he was intimidating us, but he was actually creating an unassailable mountain of proof. That night, I organized all 7 transcripts into a binder labeled Defense Exhibits. I couldn't help but laugh. They'd handed me everything I needed to destroy them. On a quiet Wednesday afternoon, I received an email from an address I didn't recognize. throwaway.justice.seeker@mailhost.com. The message was brief. I work in Titan's claims department. You didn't hear this from me, but Patricia is bragging about your case. She told everyone you'll cave before trial. They're betting on it. Make them pay." My heart raced. This was insider information, confirmation of their strategy. I couldn't use it as evidence, but it told me everything I needed to know. They weren't preparing for trial. They thought I was bluffing. I replied carefully. "Thank you for this. I promise you, they're going to regret underestimating us." Then I forwarded the email to my encrypted backup drive and deleted the original. That evening, I met Amanda at a coffee shop. She looked exhausted, worn down by months of fighting. "They're going to make another offer soon," I told her. "Whatever it is, trust me, we're not accepting." She hesitated, then nodded. "I trust you." Those 3 words carried more weight than any verdict could. The offer came Friday morning. $50,000. The email had a new tone, less smug, more urgent. "Let's avoid the embarrassment of a trial for everyone involved." I printed it and drove to Amanda's apartment. She read it 3 times, tears forming. "That's more than I make in a year," she whispered. "Maybe we should." I sat beside her gently. "Amanda, if we settle now, they win twice. They lowball you, and they get away with doing it to the next person." I showed her the research on Patricia's history. 12 other people, 12 other victims who gave up. Amanda's hands shook. She had bills piling up, creditors calling. 50,000 would change her life. But she looked at the papers, then at me. "What do you think?" "I think you deserve justice, not charity." She took a deep breath. "Then we go to trial." I filed the confirmation paperwork that afternoon. No turning back now. Thomas pulled me aside after court one afternoon, his expression serious. "You know what happens if you lose, right? Titan Insurance will blacklist you. No cases, no referrals. You'll be done." I'd thought about this constantly. My reputation hung in the balance. Most lawyers settle because losing is too risky. Going to trial is gambling your career on 12 strangers. I stood at the window of Thomas's office watching traffic below. "And if I win," Thomas smiled sadly, "then you'll have made a powerful enemy." I thought about Amanda struggling on those parallel bars. About Patricia laughing at my request for fair compensation. About those 12 other victims who gave up. I looked at Amanda's crutches leaning against the wall in my mind. "Then I'll build my own list," I said quietly. Thomas nodded, respect in his eyes. "Then let's make sure you win." He spent the next 3 days helping me rehearse my opening statement, questioning every word, every gesture, every pause until it was perfect. Jury selection took 2 full days. Preston used his challenges to eliminate anyone who'd ever been injured or dealt with insurance companies. He wanted business owners, corporate managers, people who understood fiscal responsibility. I fought back, using my challenges on anyone who seemed too sympathetic to insurance companies. One woman remained, Bethany Cole, a nurse from County General. Preston tried to dismiss her, claiming medical professionals were biased. Judge Brennan denied it. As Bethany took her seat, she met my eyes for just a second. Something passed between us, an understanding, maybe. She'd seen real suffering in her work. She'd know the difference between genuine injury and exaggeration. After jury selection ended, Preston cornered me in the hallway. "That nurse is going to be a problem for you," he said, trying to sound confident. I smiled. "I'm counting on it." That night, I prepared my opening statement one final time, practicing in front of my bathroom mirror until the words flowed naturally, powerfully, truthfully. Monday morning, trial began. The courtroom smelled like old wood and anxiety. Preston stood first, his opening statement polished and cold. "Ladies and gentlemen, you're going to hear from a woman who claims she's devastated by injuries, but you'll also hear about her daily activities, her social media posts, her ability to function. This case isn't about justice. It's about someone wanting money for ordinary pain." He pointed at Amanda like she was a criminal. "She's dramatic, emotionally unstable, and sees dollar signs instead of healing." Anger burned in my chest, but I kept my face neutral. When my turn came, I didn't say anything at first. I just walked to the evidence table and held up Amanda's X-ray against the light box. The shattered knee glowed white against black. Silence filled the courtroom. Every juror stared. "Pain leaves marks," I said quietly, letting them absorb the image. "So does greed." I lowered the X-ray and looked at each juror. "You'll decide which mark matters more." Midway through the trial, I called Dr. Harrison Blake, Amanda's orthopedic surgeon. He explained the surgery, the complications, the permanent damage. Then I asked a question I'd saved. Dr. Blake, did anyone from the insurance company contact you about this case? He hesitated. Preston tensed. Yes, Patricia Walsh called me 4 months ago. She asked if could reconsider my assessment of the injury's severity. Gasps rippled through the courtroom. What did you tell her? I asked. I told her I don't change medical opinions for insurance companies. The jury stared at Patricia, who'd gone pale. Preston shot to his feet. Objection. Hearsay and relevance. Judge Brennan looked at him coldly. The witness is describing his own conversation. Overruled. It stays on the record. I thanked Dr. Blake and sat down. I didn't need to say anything else. The jury had just learned that the insurance company tried to pressure a doctor into lying. Patricia wouldn't meet anyone's eyes. Preston shuffled his papers frantically, realizing their case was crumbling. On cross-examination, Preston made his biggest mistake. He called Patricia to the stand, hoping she could explain away Dr. Blake's testimony. I'd been waiting for this. Ms. Walsh, why did you offer only $30,000 for injuries with $36,000 in medical bills? Patricia straightened. We assess each claim carefully based on... Yes or no, please. Did you offer less than the medical bills? Yes, but... And you knew the driver's policy limit was $100,000? Yes. I paused, letting the jury absorb this. Miss Walsh, were you worried this case might go to trial? She shifted uncomfortably. We consider all possibilities. And if it did? She exhaled sharply, frustrated. Honestly, we didn't think she'd go this far. Silence. The court reporter's fingers froze on the keys, then resumed. I glanced at the jury. Bethany, the nurse, shook her head slightly. Thank you, I said softly. No further questions. That was the sound of them losing, and everyone in the courtroom heard it. Preston scrambled to recover. He called his star witness, an independent medical examiner who'd reviewed Amanda's records. Dr. Franklin claimed her injuries were moderate and temporary. I smiled because I'd been waiting for this too. During cross-examination, I pulled out his deposition transcript from 3 months earlier. Dr. Franklin, at your deposition, you stated Amanda's injury was significant and likely permanent. Do you remember saying that? He blinked rapidly. I may have used different terminology. Different terminology or different opinion? I held up the transcript. You said, and I quote, "This patient will require ongoing care for years." Were you lying then, or are you lying now? Preston objected loudly. But the damage was done. Jurors exchanged glances. One older gentleman frowned deeply at Dr. Franklin. Preston slammed his pen down on the table, the sound echoing through the courtroom. His face flushed red. Their star witness had just contradicted himself under oath, and everyone saw it. The jury didn't trust him anymore. Neither did Judge Brennan, judging by her expression. That night at 11 p.m., my phone rang. Unknown number. I answered. Preston's voice came through, tight and strained. We'll settle for $90,000. I stood at my apartment window, looking at the city lights. 9 days of trial, and suddenly they wanted to settle, because they knew they were losing. The jury is deliberating Monday, I said. This conversation is over. Wait, I hung up. Then I deleted the voicemail he left immediately afterward, without listening. He wanted me to doubt myself, to second guess, to grab the sure thing instead of risking a verdict. But I'd come too far. Amanda had suffered too much, I texted her. Final push tomorrow. We finish this. She replied instantly, thank you for believing in me. I didn't sleep that night. I rehearsed my closing statement over and over, refining every word, every pause, every gesture, until it was perfect. By dawn, I was ready. Monday morning, closing arguments. Preston went first, trying to salvage their case. He talked about reasonable compensation and appropriate limits and community standards. His words sounded hollow after a week of damning testimony. Then it was my turn. I stood before the jury, meeting each person's eyes. Justice isn't a bargain, I began, my voice quiet but steady. It's not something you negotiate down until it fits someone's budget. Justice is a promise we make to each other, that when you're hurt through no fault of your own, we'll make you whole again. My voice trembled slightly with conviction. Amanda Briggs didn't ask for this. She was stopped at a red light when someone destroyed her knee. She did everything right, and they offered her less than her medical bills. I pointed at Patricia. They gambled that she'd be too tired, too poor, too scared to fight back. They were wrong. The jury watched me intently. Give her justice. Give her the promise we all deserve. I sat down. The jury filed out. Patricia stared at the floor, refusing to meet anyone's eyes. We'd done everything we could. Now we waited. 3 hours felt like 3 years. Amanda and I sat in the courthouse cafeteria, neither of us eating. Thomas stayed with us, making quiet conversation to ease the tension. Finally, the bailiff found us. Jury's back. The courtroom filled quickly. Preston and Patricia sat rigid at their table. Judge Brennan took her seat. Has the jury reached a verdict? The foreman stood, a middle-aged man who'd taken careful notes throughout the trial. We have, Your Honor. Please read it. In the matter of Amanda Briggs versus Titan Insurance Company, we find in favor of the plaintiff. We award damages in the amount of $140,000. Gasps echoed through the courtroom. Amanda grabbed my hand, sobbing. Preston's face went blank with shock. Patricia looked like she might faint. I sat perfectly still, letting the moment wash over me. We'd won. Not just won, we'd crushed them. Judge Brennan banged her gavel. Counsel, remain after dismissal. We need to discuss post-verdict motions. I nodded, already knowing what came next. The real punishment hadn't even started yet. As the courtroom cleared, I handed Judge Brennan a motion I'd prepared weeks ago. Motion for bad faith damages and attorney's fees. I'd warned Titan Insurance in writing that their refusal to negotiate exposed them to unlimited liability. Patricia had ignored it. The jury's verdict exceeded the policy limit, which meant Titan owed every penny. Not their insured driver. Judge Brennan read through my motion, then looked at Preston. Response? He stood shakily. Your Honor, we'd like time to. You had time. You had multiple warnings from opposing counsel. Did you respond to her bad faith notice? Preston's silence answered everything. I'm setting a hearing for Friday morning, Judge Brennan said. Be prepared to show cause why bad faith damages should not be awarded. She dismissed us. In the hallway, Preston pulled me aside, his earlier arrogance completely gone. Please, we can work something out. I looked at him coldly. You had 9 months to work something out. You chose humiliation instead. When I checked my phone, there was a text from Thomas. They're panicking. Good. The insurance company's legal team knew exactly what was coming. Friday's hearing was brutal. Judge Brennan ordered Titan Insurance to produce internal communications about Amanda's case. What emerged was damning. Emails between Patricia and her supervisor showing they deliberately undervalued the claim to meet quarterly savings targets. A memo from Patricia stating, claimant appears financially desperate, unlikely to reject settlement. Messages joking about playing hardball with ambulance chasers. The judge's expression grew colder with each exhibit. Preston tried to explain, but his words sounded pathetic against the evidence of intentional cruelty. During a recess, I saw Titan's corporate representative in the hallway, phone pressed to his ear, whispering urgently. When court resumed, he approached the bench. Your Honor, Titan Insurance wishes to settle all outstanding matters immediately. Judge Brennan looked at me. Counselor? I stood. We're prepared to accept full payment of the judgment, plus our attorney's fees, court costs, and an additional $50,000 in punitive damages. Preston looked like he might cry. And, I added, a written apology to my client. The corporate rep nodded frantically. Agreed, all of it. 2 weeks later, Amanda sat in my office holding a check for $190,000. The jury verdict, punitive damages, and everything else. She stared at it like she couldn't believe it was real. I never thought. She looked up at me, tears streaming. Thank you. We hugged, and for the first time since taking her case, I felt the weight lift from my shoulders. The written apology arrived that afternoon, signed by Titan's CEO. It acknowledged their mishandling of her claim and promised internal reforms. I knew it was corporate damage control, but Amanda deserved to see them admit fault. The local news picked up the story that evening. Small firm lawyer defeats insurance giant in bad faith case. My phone rang constantly, reporters wanting interviews, lawyers asking for advice, potential clients seeking representation. Thomas called, pride evident in his voice. You didn't just win, you sent a message. That night, I celebrated alone in my apartment, drinking wine and reflecting on 10 months of battle. We'd won, But more importantly, we'd proven that bullies lose when someone fights back. The emails started arriving Monday morning. Dozens of them. People who'd been lowballed by insurance companies, who'd given up, who'd accepted unfair settlements. They thanked me for showing them it was possible to fight back. Some shared their own stories. Heartbreaking accounts of injuries and injustice. I couldn't take all their cases, but I referred them to lawyers I trusted. One email made me pause. I settled with Titan for $20,000 last year. After seeing your case, I realized they cheated me too. I felt anger and sadness. How many people had Patricia victimized? How many gave up before finding justice? That afternoon, a woman walked into my office without an appointment. She was maybe 30, walking with a cane, carrying a thick folder. "My name is Olivia Torres," she said quietly. "I was rear-ended 6 months ago, herniated 2 discs in my back." She set the folder on my desk. "Titan Insurance offered me $15,000. My surgery cost $22,000. I opened the folder. Medical records, bills, correspondence, and there, an email from Patricia Walsh. I looked at Olivia, then at the folder, then back at her. "Tell me everything," I said. As she described her accident, her pain, Patricia's dismissive responses, I felt that familiar fire building again. Titan Insurance hadn't learned anything. Patricia was still there, still victimizing people, still gaming the system. But now I had a reputation. Now I had a track record. Now I had proof that fighting back works. I smiled at Olivia. "I'll take your case." Over the next few weeks, 3 more clients came forward, all with Titan Insurance claims, all lowballed by Patricia Walsh. I filed all 4 cases simultaneously, requesting they be heard by Judge Brennan. The story made the news again. Titan's stock dropped 2%. Patricia was quietly reassigned to a desk job processing paperwork. Not fired, but neutered. Some people think revenge means shouting or slamming doors. I disagree. Real revenge is letting the system you've mastered do the punishing for you. They thought they could lowball me, intimidate me, outlast me. I let them discover the hard way that I don't bluff. Justice doesn't need anger. It just needs a good memory. And I remember everything.